Hi, everybody, and welcome to Immigration Policies Q&A with moi, Nicolette Glazer. I hope you are all doing well, and I thank you if somebody joins me. But anyways, I am glad that I can broadcast again. There was a problem. And I wanted to talk to you today about a few things. First, as we speak already, the Laken-Riley Act is part of the Title VIII, or as we call it, the Immigration Nationality Act. It was signed today by President Trump, and it is the first legislation of his 47th tenure, and obviously the first immigration act that we have of this legislative session. So a big deal. So I wanted to talk to you about that. I have a lot of interesting questions about it, and I appreciate you chiming in on that. And so I'll try to answer them. And then I will try to answer some question I got in advance about some practical aspects of what's going on in immigration, specifically the raids. It seems to be something of interest. Now, if you would like to post some comments, or if you want to ask a question, please do so on Twitter or Instagram, or I think it's on YouTube too, and I'll try to check and I can figure it out. I will try to answer the questions. Again, I hope you will forgive me. There's some glitches till I figure it out, but it's a new program, so it takes some learning. So, first, before I start talking about the Laken-Riley Act, I feel like I have to make this disclosure, and that is, I'm probably going to be very critical of time about the statute and what Congress did, but I want to make sure that nobody misunderstands that as in any way as a critique or me not understanding the tragedy that prompted that somewhat misguided act. Nothing can bring Laken Riley back to life, and that was an incredible tragedy, and it's unfathomable what happened or the depravity that this individual displayed and what he did. But what we have here is a statue that was passed. In a way, they tried to do it as an honor to her. I do hope that her family was on board on that, and if that is so, then I hope that it brings some solace to them and some peace. I do hope, and I'm going to say, Laken Riley, rest in power. It was unfathomable what happened to her. But what we have here now is a statute, and that statute is applied to uh, everybody that can fall within, and it becomes and has a life on its own. And so when I talk about it, please do not take it as some sort of a slant or a critique of like or justifying what happened. It's as I said, it's an unfathomable cruelty and depravity, and I don't care what the immigration status of the person her killer is. I don't. It is just an act that is defy humanity, and it should never happen. Unfortunately, it does happen, and I don't think that you can solve that problem or eradicate depravity by passing a statute of this kind. But with that said, I just wanted to make that. I felt like I needed to make that disclosure. But what Congress did is really very, very consequential. And I'd like to kind of give you an idea of what I see there, and then I want to answer some of the questions that I got over the last few days about it. So, the statute that was passed by Congress is a very limited in a way, and yet it has a tremendous impact and will have a tremendous impact. So before I go, and it seems like somebody asked me, well, would would that act now make more people subject to be deported? Well, no. And I say that because this act does absolutely nothing to expand the grounds on which a non-citizen could be basically removed, or as it's used colloquially, deported. What the act actually does is address a very specific aspect of the removal proceeding, and that is something called mandatory detention, which is different than the removal proceeding itself. And it also affects only a subset of non-citizens that could be subject to removal. And so I try to explain that to people, and it is a little difficult because there's a lot of legalese, a lot of terminology, and a lot of people may not understand that. The way that the INA, as we currently have it, was structured, it kind of divide people, non-citizen, who could be deported. And I'm using deported just colloquially. The current and proper term is removed. It's done, and so those two people are divided, or the distinction is made by the way they enter the country. So you have people who are considered inadmissible, and those people basically are a group of people who did not have a visa, U.S. passport, or any other form of a entry document that allow them to be inspected by immigration officer and admitted in either non-immigrant or immigrant status, or as refugees. So that's what's called inadmissible. Now, these people also, in the group of people that is covered, and also people who never like went through inspections. So what we call entered without inspection, or EWI. And that's a vast majority of the undocumented population. And so they're considered applicant for admission. Although they are physically in the country, some of them are paroled. Even that grace of parole, it's only a legal fiction that overcomes the fact that they aren't what's called an applicant for admission. So for purposes of the immigration law, if you were not admitted into the United States by an immigration officer in non-immigrant status, refugee status, or as an immigrant, you are considered to be stuck still at the border, even though you are physically in the country. It's called the entry doctrine. And so those people who are at the border, stuck at the border in the eyes of the law, do consider to have less rights because they have not been admitted and they have not established legal ties within the context of the Immigration Act. So the Lake and Riley Act only affects the detention of this first category, inadmissible non-citizen. The second category is deportable in non-citizen, and those are people who are admitted, and let they say they've overstayed as their visas, or even green card holders who have committed an offense or another triggering event that subjects them to removal, meaning taking away their green cards. Now, the Lake and Riley Act does not affect in any way that second category, with one exception. When a person who was previously admitted, let's say a green card holder, and I got a lot of this question and a lot of anxiety among people on that issue. If you have a green card, you obviously are a landed immigrant, and obviously you have the right to travel. If you travel outside of the country, when you come into the United States, if you fit certain parameters, you are still an applicant for admission. And so if a person has committed a crime or has been arrested, arrested for a theft offense, that person holding a green card may be considered inadmissible on entry and could be subject to this potential drastic mandatory detention. So practically, what this act did, and I think it was unintended consequences because I don't believe that's what they were looking to do. It, in a way, it renders a tremendous amount of people subject to the threat of being mandatorily detained for unidentified period of time, simply because they have been arrested for a theft offense, an offense against a law enforcement officer, or an offense that have resulted or could result in a significant bodily injury. So, as I said in the beginning, the lack does not create a new form of or a ground for removal. It operates entirely within the current parameter and scope of the INA, but it introduces for the first time the concept of pre-trial mandatory detention. And by that I mean it does render people who fall within the ambit of the statute, meaning they're inadmissible, they're considered inadmissible under the INA. They could be, and there's a directive to be detained and detained for the entirety of the removal proceeding, immigration court case basically, if they have been arrested, have been convicted, or admit committing an offense, or admit to the element of one of the offenses that I identified. So to comprehend how expansive that is the fact that until now, until today, there is the criminal grounds for removability under the INA could be only triggered if a person has been convicted of a crime, and in very small circumstances, admitting to the element of offense. But prior to that conviction, a final conviction in the eyes of the state or federal jurisdiction that engaged in the criminal prosecution, the individual cannot be charged with a criminal ground of removability. And so nothing the Lake and Riley Act did changes these facts. But because people are inadmissible, meaning they do not have, and that's what they were looking for, the vast majority of undocumented individuals who entered either as gotaways, sneaked through the border and were never apprehended, or were paroled by the Biden administration or before, this group of people with inadmissible non-citizen now can be arrested, can be detained by an immigration officer as soon as they are released from the charging agency, simply based on an arrest. So it doesn't require a conviction. And also, that's the biggest concern for me, it doesn't require a correspondent arrest and a conviction even. So to give you an example, somebody who is arrested for, let's say, a shoplifting, bad thing, but I'm not going to discuss why an arrest for somebody who's innocent may happen. You all know about it. But if an individual is not a United States citizen, if they are inadmissible, meaning that they entered without inspection or they have a parole and they were arrested for a shoplifting, the moment that the immigration officer issued a notice to appear, which is the charging document to start the immigration case or the removal proceeding, that parole is terminated. So this person will be left without any lawful status because parole is temporary. It can be revoked at any time with notice or without notice when it's automatic by the issuance of an NTA, a notice to appear. So a parolee who is arrested for a shoplifting and is released by the state where that commission occurred or the judge that is overseeing the case. That individual now is subject to a mandatory detention, meaning that the statute kind of mandate for the ICE to issue a detainer and to expeditiously take this individual in custody and keep them in custody until their removal proceedings are completed. Well, here's one aspect, and I think somebody raised that to me yesterday on a phone call. And it was a very interesting question. The question is, what if the person was arrested for shoplifting, let's say, but it was a minimum amount. The prosecutor offered a deal, and the deal was, we are going to amend the information, because let's say it's a misdemeanor, and we are going to change the charges from shoplifting to disorderly conduct. Not going to discuss why that may happen, but there's valid and everyday occurrence where the original charge is amended and a person pleads to a lesser offense. So let's say that happens, and so the person who's arrested for shoplifting end up with a plea deal and a guilty plea and a conviction for disorderly conduct. Let's say no jail time, maybe let's say 1 year unsupervised probation because it's a first time offense. Well, that person will not be subject to removal because a disorderly conduct for criminal grounds, because disorderly conduct is not a triggering conviction. And that person probably would never have been subject to a detainer because that person probably did not get into a state custody. But simply because there was an arrest for a theft offense, if you read that statute as it is written, that person will be subject to mandatory detention. Now, they are removable because they do not have a status. That's because they're inadmissible. However, just because you are inadmissible, it doesn't mean that you do not have the right to apply for a relief while in immigration court or in expedited removal even, and obtain a status, lawful status granted to you by an immigration judge or the United States Citizenship and Immigration, so the USCIS. But what this act does is a person who may have and may be granted actual relief, let's say asylum, adjustment of status, a cancellation of removal, those are all form of immigration relief that gives a person either a green card or an indefinite asylum status, meaning lawful status in the United States. That person will be held in mandatory detention for the duration of that case, that immigration case. And it could be a year, sometimes it's longer. And what we have here is we have a mandatory civil detention that does not appear to be subject to any exceptions. And I think that is a staggering change to introduce into immigration law. Because as I've said, if you ever follow me on Twitter or anything, or I've discussed with people, the current Title 8 already contains very specific and expansive grounds for mandatory detention. It is in the context of expedited removal. We have within the ability of the agency to have enough space, detention space. People who are subject to expedited removal are to be detained pending their removal or pending their credible fear interview. People who have committed certain offenses were subject to mandatory detention and always have been. People who have a final order of removal and are custody, they are subject to custodial detention while the government tries to execute the final removal order. So before the Laken-Riley Act, the mandatory detention was very pervasive and affected those that really had Congress had made a decision should be detained and not released while their immigration cases are ongoing. But what this act did, it created an entire new basis for mandatory detention that is absolutely untethered to either the severity of the crime, because what you can have here, you can have somebody that is being arrested for a minor offense and that offense can be dismissed. We may have a burglary charge that was filed and then the person plead to a lesser offense. And you can have other circumstances in which there is never a conviction, or there's a conviction that cannot have immigration consequences under the Title 8. And yet, these people will be subject now to mandatory detention. And I don't think this is very, very monumental change, especially, I think, in a context of one particular group. And that somebody asked me yesterday is like, how is that going to affect Cuban a national who already have an application for adjustment of status under the Cuban Adjustment Act? Well, just if you don't know what that is, in 1960, the Congress passed one probably of the most important and the most, you know, humanitarian statute that affect immigration with something called the Cuban Adjustment Act. And it basically provides that Cuban nationals who are paroled into the United States have and remain in the United States for 1 year in parole status and are not otherwise inadmissible can adjust their status. It means they can get a green card. And so what we have, obviously, for the last 4 years, there were a lot of Cuban nationals who were paroled in the United States, either under the CHNV parole program that Biden administration introduced under 212 D5, which is the standard parole provision, because they were at the border and the CBP, the border patrol officer, exercised discretion and parole that individual in the country. And it's quite often that we have the Cuban national paroled in light of the Cuban Adjustment Act. So if somebody is paroled and they have 365 days of physical presence in the United States in parole status, they can apply for adjustment of status. Adjustment of status is basically the name given to the process that somebody starts when they apply for a green card. So a lot of people who came in more than a year ago, who are Cuban nationals, and also spouses and dependents who doesn't need to be Cuban national, but if they're married to a Cuban national, they have actually filed adjustment of status applications. And so if somebody had an application pending, so it just takes time for this application to be decided, and a person like that is arrested for a theft-related offense, well, technically under this act, the person is subject to mandatory detention. Well, think about it. This is a person who is still admissible because they have not been convicted of any crime. This person may end up with a misdemeanor conviction with less than 6 months of jail time, which falls with what's called the petty theft exception. So that person, even with a petty theft conviction with a sentence of less than 6 months, will be eligible to get a green card. I mean, that is the statute. It's undisputable. So that person will be able to get a green card, even if they get convicted for that offense. And yet, they will have to be mandatorily detained until either a USC officer, if they apply to it, or an immigration judge hands them a green card. I mean, in what reality is that a reasonable approach to take? Now, I'm giving you example of stuff that are perhaps unintended consequences, but these are realistic scenarios of situation which we're gonna be encountering over and over and over again. And it will affect people and families to an extent that is difficult to comprehend. I mean, punitive civil detention is not permissible, with a very limited exceptions. What this act does is normalize such a pre-trial, pre-conviction, indefinite mandatory detention. And it is the kind of detention that really cannot be challenged. And so it makes it tremendously difficult for us as practitioners to be able to minimize the trauma to people and families. And it brings a tremendous amount of pain and suffering for the people who are subjected to that. And again, there are people who should be detained. It doesn't matter what the citizenship, what the status is. And that's already part of the INA. That's why the INA does not allow people who have a triggering and immigration consequential criminal conviction to obtain relief. That's already there. Congress have done a lot of that already. But what this act did, and I think the idea is that they were trying to tailor a provision so that Laken's killer would not have been able to roam free and commit a despicable offense. But that's a very odd way to try to structure a statute. It's not going to bring her to life. It's not going to change anything for this killer. But in a process to prevent further tragedy, they have created a situation where a lot of people will be victimized for transgression or for something that will not necessarily have a consequences for them obtaining legal status. So the people will, despite this act, because the draconian aspect of this act, will continue to be and remain in the United States because despite the detention, they may obtain asylum, they may obtain adjustment of status, cancellation of removal. I'm not going to go into that, but that is a reality that happens. Now, the other aspect that I worry is that, and that's a kind of reality that, again, it was not thought about it. Successful criminals, those who have made crimes their occupation, generally are have disposable income or they can get money. Those people were likely to obtain counsel, and an attorney may be able to work around, obtain a bond, argue that it doesn't fit with certain definition or whatnot. What is going to be the most tragic aspect is that it is going to be the toughest and it will have the most severe consequences to indigent criminal defendants that were charged for a minor crime that because if it was relatively minor, they did not receive a public counsel, for example. In some jurisdiction, that's not an automatic, or they received a disposition, criminal disposition that an overworked public defender thought was the best thing because the person will not spend time in jail. And then once that plea deal is entered and is done, then the immigration consequences come in. And because often people in detention cannot afford to get a counsel to represent them, those people will, even if they had an opportunity to legalize their status, will be deported. I mean, a lot of people think that, every time you see, and, everybody hates lawyers, and I don't blame anybody about that, but that's a reality. You go, if you have a problem, you go to a lawyer and a doctor. You don't want to see those two professions unless you have problems. But if you can afford to go to a lawyer, you have a much better chance to get out of removal proceeding holding a green card or another form of relief. Very few people can navigate that Byzantine system by themselves. And because non-citizens do not have the right to an appointed or a free lawyer, you either have to pay for an attorney, or you have to find somebody to do the work pro bono. Well, lawyers, as much as you hate them, are a finite resource. So we cannot take every single case. And when the system gets overloaded, that's what we have now, there's not enough lawyers to take the cases, even if we want to. And NGOs that are providing legal services for free or for low cost are so overloaded and so overburdened that they can barely represent a small fraction of the people who come through their doors. So they have to make a choice of trying to provide limited representation, certain orientation, know your rights, some form preparation. so that they can help more people rather than provide a full scope representation end to end to few people. And so that's where we get into a large population of detained non-citizens. That's when we have these rocket dockets that end up in removal proceeding really fast. And once a removal is entered, yes, you can appeal. Likelihood to succeed are very small. And once it is executed, meaning people are actually physically removed because of a final order of removal, people are subject to 5, 10, 20, or forever to a bar to re-enter. Meaning people get separated from their lives, sometimes of decades, from their families. And guess what? A lot of time, people who are deported, they spend few weeks in a country that they don't know, and they make the horrible decision that they have to make it back. So they hire um, like smugglers, or they sneak through the border, and they're back in the country. They are hiding because if they are apprehended, the order of removal will be reinstated. They will be taken in detention and they will be sent again. And if it's a certain category, such as if you have been deported because you're for aggravated felony and you re-enter, then you are subject to criminal enhancement for sentence purposes and criminal prosecution, and people spend years in jail for that. And it's made a lot of time out of desperation. And so the more you build on this enforcement, mandatory detention, mandatory removal, mandatory limitation of right, you basically are expanding that large group of people who go into the shadows, and they become a form of a second class individuals, human beings that are subject to exploitation, that are subject to extortion, and it's in a vicious perpetual circle that never ends. So this is why I see this particular act as extremely, extremely dangerous and with severe consequences for people. So people who represent individual, this is going to be a major, major change in the rules of the game. And if that applies to criminal lawyer representing non-citizen, you cannot just know a little bit about immigration law, because anything you do will now trigger potential mandatory detention. As immigration practitioners, you need to be really well versed, if not even an expert, in criminal cases, in criminal law, so that you can properly and zealously represent your client. And if you are a non-citizen and you have any criminal record, I mean, pretty much the game starting today is very different. I mean, a person can be subject at any time to be picked up. You never know, because as Holman likes to say, they're looking for somebody, and if they encounter somebody else who is not on their list but is removable or inadmissible, they're collateral. They get arrested and they get put in immigration detention. If you fall within a category covered by this act, that will be a mandatory detention, meaning you cannot be released and you cannot bond out before an immigration judge. And so with that comes the reality that you have to fight the case while detained. Well, guess what? Very few people are able to withstand that rocket docket that is the detained immigration docket, nor the tremendous trauma of being detained. Now, you have to understand, it's one thing to talk about a sentence that is being served by somebody, that is part of the consequences of a criminal conviction. But what we have in an immigration context is people who have paid their debt to society. They have served their sentence, or there was not a custodial sentence. What the Immigration Act until today, amended by the Laken-Riley Act, now makes certain large group of non-citizens potentially subject to punitive civil detention. Now, when people don't understand is that immigration detention, when we call it civil, it's only civil in nature. It's an oxymoron. People are held in county jails. People are held in for-profit private jails. And those are actual jails. They're detention facility, most often next to a state prison or part of a large state prison complex or a federal detention complex. People are in like held, their rights are restricted. They wear orange, blue, or red jumpsuits. They are their every inch of their human dignity is taken away, and they are often screamed at, abused verbally by officers who just had a bad day, or they just simply take their own problems on detainees. I mean, I'm telling you that because I have witnessed it, or or I have represented people who have been in that situation. Now, for anybody who takes the position, well, there's a non-citizens, ergo they are, like yesterday the press secretary said, they're all criminal. Well, no. People who enter unlawfully, not in a designated port of entry, could be prosecuted for a misdemeanor under federal law. People who re-enter after private deportation could be prosecuted. Those are criminal offenses. However, and that it's okay, even some weird context, to call people like that criminal. But people who have entered with a visa and have overstayed, they have not committed any criminal violation because remaining without a status is not a criminal offense. People who have worked without authorization may have committed a civil violation, or in the eye of many, a moral infraction, but that is not a criminal offense. Having been ordered removed and having a final order of deportation, and you're not departing in time, may be a civil violation of the act. It may subject you to some very unhappy consequences, including fines, but it is not a criminal offense. So when people take that derogatory approach that, well, immigrants, all immigrants are criminal, or everybody who's here unlawfully is a criminal, it is in a very slippery slope to basically deny the dignity of a person. I mean, I said it, no human being is illegal. They may have committed acts that are unlawful, that's fine. You can judge it. Every jurisdiction or sovereign has the right to decide and elevate certain acts into crime and decriminalize other. That's part of the police power of a sovereign. But to simply label people as illegal is kind of, it's just absurd to me. So I will continue to talk about undocumented non-citizen because I don't know a better term or how to define it. And I also continue to refer to people as non-citizens, despite of what the INA said. Yes, the INA refers to aliens, and it is an idiotic term, but it's part of the legal, it's on the books. However, I'm not using that term. So I already saw somebody who was reminding me that it refers to that term even at the end. That's correct. And I choose not to use that. So basically, that's kind of what I wanted to talk to you about the Laken-Riley Act and what it is with the mandatory aspect. But there's one other aspect that kind of went under the radar, and I'm not sure why. And that is the mandatory detention is basically 3 paragraphs. The rest of this statute, which again is only 9 pages, I think, and those are not real pages, but the way it is done, um, refers to something completely different that has nothing to do with detention, removal, or pretty much nothing. And that affects the provision that they put in that gave a state attorney general the standing to sue the federal government as long as they can show that there is at least $100 harm to any of the residents or to the state itself. And then they can seek a federal district judge to issue injunctive relief against the federal government for not detaining enough people, for paroling people, and in certain aspect is to seek a federal judge to stop or order the State Department not to issue visa to countries that do not accept their citizens back. And so, why is that relevant? Well, first, it provides a tremendous amount of power to attorney generals to basically interfere and potentially, not sure, we don't have not seen it, but potentially to change even individual decisions, not only policy and practices of the federal government as a whole. But what it did is, and I think that's I'm still trying to grapple with what that means, is for the first time that I'm aware, it Congress basically shared that exclusive plenary power that the Congress and the executive had over immigration forever. And now they're sharing that plenary power with the state attorney general. I mean, that is an incredible concessions to make, because time and again, if you read any of the old Supreme Court decision, or any time the Supreme Court will, revert to the finding a way to explain why something that is obviously unconstitutional is still constitutional because it applies to non-citizen, they resort to this plenary power doctrine, which always is been taught as being rooted in the Constitution, yet I think it's a completely, judge-made doctrine, but it's a political doctrine that says Congress and the executive are the one that decide basically everything that there is to decide about immigration, because immigration touches upon political power, it touches on diplomatic relations, and we are going to let them have this exorbitant discretion to deal with anything in immigration. So judges butt out. Well, what they did in this plenary power they held to cling to so for so long, they now have decided to share with the state attorney generals. So now we have Congress that can pass basically any law that they want as long as it is related to immigration. We have the executive headed by the president that have a tremendous powers in this field because of the way the INA is written and because of the constitutional aspect of executing laws and everything else. Now we have state attorney generals that are going to be able to seek injunctions or appropriate injunctions for anything they don't like when it comes to how the federal government is processing cases. That includes detaining people, placing in removal proceeding, removing it quick enough, detaining them, and potentially issuing visas. I mean, that is a staggering departure. Now, somebody yesterday DM saying, well, that expansion of standing appears not to be constitutional and it's not going to withstand Supreme Court scrutiny. Well, maybe. I don't know. I certainly am not an expert of standing, but I do know enough to know that it is such a murky concept that you can drive a Mack truck through any of the exception or any of the formulations. So it could be stricken and most likely will be blessed by the Supreme Court if it when it goes there, because Congress can create standing if they see fit in a context that is entirely within their basically scope of authority or the plenary power. And of course, if they want to, they can always dust off that old saying they have is, well, Congress can pass law that are unconstitutional when applies to U.S. citizen, but they can be unconstitutional and still be fine when because they apply to non-citizens. So when you have that kind of a gloss of prior decisions, and there are plenty of them, I'm not sure that it's very clear or that's clear cut that the standing that they have created is not permissible and it will not going to withstand. And so, could it happen? I don't know. We'll see. I'm sure there will be some decisions that will kind of quickly go up to SCOTUS, and maybe they will take it. I would think they would, and we'll see where it goes. But I don't think it is that clear cut, and I don't think there is directly on point decision that makes it unlawful. I mean, again, they have chipped away understanding of the states and what they do. Yes, but that's what Congress went in to remedy, and Congress can and has the authority in certain circumstances to create standings. So it is a very much more thorny legal issue, I believe, and for people who actually know about it to discuss. But I don't think in a immigration act sphere we can say, oh, it's gonna go away because this is clearly not in compliance with standing. Now, the other thing I kept hearing, and somebody asked that also, is, well, because they gave this very low threshold standing to state attorney generals, can, let's say, attorney generals that are opposed to detention or want to protect non-citizens, right? Can they use this Lake and Riley Act and file a lawsuit in a friendly district court and obtain an injunction? Well, I think the way I read the statute, I don't think so. And the reason for it is that it specifically allows for injunction with respect to acts that were already enumerated in Title 8. And all of these enumerations are restrictive. They relate to must be detained, must not be paroled, or must not be do this, must not. So I don't see how the actual text of this standing provision can be twisted into allowing, let's say, a blue state attorney general to sue the agency for detaining too many non-citizens, because the way, like section 235, one of the provision is it's require mandatory detention. Now, the Supreme Court, when had to grapple with that, says, well, it's within, no administration, and there's not enough detention space, so it's not practicable that everybody has to be detained. But it's still built on the same mandatory language, which I think is going to be very difficult to twist into saying, yes, it says you shall remove or you shall detain, but we are going to see it as a way to sue because it's, let's say, denies asylum aspect, or it does not, it would hurt the state because families are separate. I mean, I hope it's going to work, but I think it's going to be a stretch based on the pure statutory text. Now, obviously, judges can do a lot of things, and a favorable judge can enter a decision that is favorable and then let it go up on appeal and see what happens, the same way as judges in different jurisdiction will be quick to grant injunction, saying, well, you have to detain everybody who is in, let's say, in Texas and that doesn't have documents. And again, send it up and see what happens on appeal. But again, I don't see it as being so clear cut that you can do that. Not to mention that, it's going to be a very difficult, probably, argument to make, considering that equitable relief within the context of INA is somewhat limited. And so, unless there is another source of restriction or a constitutional aspect that can be asserted, I think purely equitable grounds to prevent the agency from doing what they are given exclusive authority to do is probably not going to be an easy thing to do. But again, we'll see. And I promise when those lawsuits start going, I will cover it and tell you what's going on with it. And so kind of this is what I wanted to talk to you. And I wanted to check to see if you guys have sent me some other questions that are of interest. And I see in my DM somebody is asking a question that is a little personal and it contains personal information. So I am going to have to paraphrase it. So a person is asking me if somebody who has been arrested in the past for a theft offense, but that theft offense has been dismissed, would they be, I mean, it didn't result in a conviction. And I'm not sure if it means that it was dismissed for a legal reason, meaning it was dismissed for failure to prosecute, not prosecuted, or it was some sort of a remedial change, but the person says it was dismissed. Would that person be subject to mandatory detention? Well, again, not able to answer that question because I don't know the facts. So I'm going to use the question to kind of answer it more as a general proposition. So let's say you have been here for a while and you have on your rap sheet a arrest, and that arrest shows for a statute that is a theft, let's say, related offense. Well, the way it is written, if you are inadmissible, meaning if you entered without inspection, and you can be considered a applicant for admission and charged under Section 212. The way the Lake and Riley Act is written, then yes, that you, as being that person, could be subject to mandatory detention. I mean, I think most likely that's what the government is going to argue and resort to if a person like this come to the attention of the Immigration Act. Now, is it how relevant that is going to be? I can't tell you because, if you have other form of relief, maybe you can get an expedited hearing and get a quick decision by immigration judge. So, you're gonna endure a, mandatory detention, which is going to be hellacious, but you still may be able to remain in the United States, let's say, with your family. But if you do not have a avenue of relief, meaning you don't have a pathway to get a green card or another form of permanent relief that will allow you to stay in the United States, such as asylum, withholding of removal, protection under the Convention Against Torture, then a simple arrest with no conviction could result in removal proceedings be initiated and you be mandatory detained. Absolutely. So that's why I said this is very, very potent statute that potentially subjects a lot more people to consequences that we did not have to worry about. Meaning people who had an avenue to legalize their status, they get placed in removal proceedings, and after 2, 3, sometimes 10 years, they get their green cards and it's expensive, it's nerve-wracking, everything else that you can describe it, but ultimately they get that. I think with this new aspect of mandatory detention, it becomes very different. And so that's why I said it is a game changer for people who do not have green cards, and a subject to detention for anybody who actually holds a green card and decides to travel because they have the ability to do so and may end up in trouble because of an old conviction or an old arrest that will end them inadmissible in the eyes of an officer, even if the officer is wrong, or for us as practitioners. And I say practitioners, not only immigration lawyers, but criminal lawyers. And so it's very, very stressful place to be right now if you are, working in this particular area, because any oversight or any mistake could have tremendous consequences in with a relatively small criminal case. So that's kind of the best answer I can give you on that. I got a few more that are very kind of case specific, fact specific. I don't think I can answer those at this point, but you're welcome to give me a call if you want to have a consultation with me. Certainly not inviting that, but I don't think I can answer those questions in a public broadcast. So with that, I'm going to say goodbye for today. And I hope that you will join me again. And again, if you have questions about a lawsuit that is being discussed somewhere that is immigration related, let me know. I'll take a look at too many of them and I will talk about it. Actually, next week, I want to talk about a few of the immigration cases that are kind of starting to pick up steam. So I will let you know a few days in advance which one I'm going to talk about it. And hopefully I'll see you next time. Bye, guys.